Welcome to Justice Arena.
Do you have a lawyer?
No, I do not, sir.
Are you going forward without a lawyer?
Correct.
Your Honor, the parties have conferred. Mr. Garcia is here to let the court know that he is still willing to go forward with the termination of his parental rights. Ms. Garcia and I have been circulating, Ms. Leti Garcia and I have been circulating an order of termination with all the terms that were agreed to. Once we finalize, I guess, the conservatorship issues, we were going to present that to Ms. Catherine Garcia for any additional revisions that she might need, but the parties are in agreement to terminate those parental rights of Mr. Jose Garcia.
Well, I guess I need to ask you, Mr. Garcia, did you hear and understand what Attorney Soto just told the court?
Yes, I did, sir.
Is this your agreement?
Yes, sir.
Have you reached this agreement freely and voluntarily?
Yes.
Ms. Leti Garcia, go ahead.
Judge, I had occasion to speak with both of the parties. I've met the children as well. If the court recalls, this is a case that it's unique in a sense that some issues had arisen requiring a hearing at the last setting. There were certain matters that were raised that I think concerned the court. However, at this point, having discussed those matters specifically with Mr. Garcia and with Ms. Arce, I am assured and feel confident enough that Mr. Garcia understands what goes into the actual termination of the parental rights, that there will be no visitations whatsoever, even from afar, that likewise he will have no further obligations for the payment of child support or for health insurance or any unreimbursed or uninsured costs. There will be no social media statements or messages made either out there in public or in a private setting. No pictures will be shared or will be requested by him or any of his family or friends or any other relatives that he might have. And just perchance, he happens to maybe run into the children, perhaps at a store or at a mall, that he take necessary precautions or actions to perhaps steer away from them at that point. I think that would be the easiest manner for the children to understand that this is a permanent thing. And he did advise me that he understands it, that he's willing to undertake those actions and behaviors and thereby create peace for the children. And one other thing, the school is included in this, Judge. He can't go to school anymore and speak to them in classes or their teachers. And I'd like to ask Mr. Garcia, you do understand everything I just said to you again, correct?
Correct.
Do you have any questions or concerns or problems with this?
No, I do not.
I know it was difficult, Mr. Garcia, and we discussed that. In your particular case, there are other issues that could have likely become a problem, and or might have already been a problem. And in that light, I respect your decision and your choice, and the fact that you're doing this for the sake of the children. And Judge, it is my recommendation, therefore, that it is in the best interest of the children that the parental rights be terminated between father and the two kids.
When I heard Ms. Soto, I thought you were going to circulate an order and present at a different time. But you all are asking to do this prove up today, Ms. Soto, Ms. Garcia?
I wanted to put it on the record, Your Honor, for myself, because I wanted to include these additional statements in an order, which is not customary in our normal formats. And so that's why I wanted to put these extra things on the record so that I can reduce that also into writing. If the court will recall the last hearing and the issues that came up with this case. So
Yeah, I'll make some reflections on that matter momentarily. But Ms. Soto, is this an announcement for approve up in the future? Or is this approve up today?
We can prove it up today, Your Honor, if Ms. Garcia or Mrs. Catherine Garcia doesn't have any objections to approve it.
Ms. Garcia, Ms. Catherine Garcia?
Your Honor, I would just say that it does sound like there's an agreement among the parties, and that the ad litem's basing her recommendation on the agreement of the parties. And I think legally the court is not bound by an agreement of the parties on a suit to terminate rights. There still needs to be evidence, clear and convincing evidence, that termination of the father's rights is in the best interest of the children, and the court's decision needs to be based on that, not just an agreement of the parties. So that would be my only objection. I don't know that it would really be a prove up, but that would be my objection, is that I haven't seen or heard any of the clear and convincing evidence of termination rights being in the best interest of the children.
And understood. Ostensibly, that is likely coming, or otherwise it'll be denied, right? That's likely coming as part of the testimony of the parties. So I guess let me give you a chance to re-object at the conclusion of the testimony. One comment with regard to any and all of this, Ms. Soto, Ms. Garcia, and Ms. Garcia, is I just want to put clear on the record. I know that the court had made a preliminary finding, or at least an observation at the last hearing, and the court required an order, and the court hasn't signed that order. Subsequent to that, the court appointed Ms. Leticia Garcia as the attorney ad litem, and what the court reflected on, and I'll put this on the record, the court heard either argument, evidence, and or testimony at the last hearing as to conduct that was relevant to the court making a decision, and based on that, the court made a finding. On reflection, since it wasn't a request by any of the parties, but something that was relevant to the well-being of the child, on reflection, the court appointed Ms. Leticia Garcia and was going to ask her to make the request if necessary. In other words, it can't be a request made by the court done sua sponte unilaterally. But if, in the opinion of the attorney ad litem, that issue needed to be fleshed out, then she, as the court-appointed attorney ad litem, can make the request, and the court, if given sufficient information, cause, reason, and basis, could grant the request. It sounds like none of that may have been necessary, and the parties are ready to proceed. Based on all of this, Mr. Garcia and Ms. Arce, please raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Your Honor.
Both have answered yes. Ms. Soto, you may call your first witness.
I'll call Ms. Arce, Your Honor.
Go ahead.
Ms. Arce, your children are Natalie and Nathan, correct? 7 and 6 years old?
Yes.
And they're currently living with you, correct?
Yes.
What school are they attending?
Aren't elementary.
Okay. And back in May of 28th, 2025, Mr. Garcia asked you to prepare documentation in order to have his rights voluntarily terminated, correct?
Yes.
You had not asked him to do that. That came of his own voice.
Yes.
And had the relationship between you, Mr. Garcia, and the children become impracticable for the kids' best interest?
Yes.
Were there serious communication issues between you and Mr. Garcia?
Can you repeat the question?
Yes. Were you having communication issues to co-parent with Mr. Garcia?
Yes.
Who do you believe was communicating with you instead of Mr. Garcia?
Mr. Garcia's wife, Tiffany.
Okay. Was she making derogatory remarks about you to your children?
Yes.
What kind of remarks was she making towards your children about you?
That I was a bad mom. She would call me a witch. And she would also make comments about my partner, the kid's stepdad, that he didn't love them and that they shouldn't love him.
Was there any comments that she made to your kids, to you or to third parties regarding your ability to care for your children?
Yes.
What kind of comments was she making about your caretaking abilities?
That I was dirty and I didn't take care of them.
Yeah. Do you have reason to believe that Mr. Garcia's spouse was the person that anonymously posted on the Mommy and Me Facebook page?
Yes.
How do you know, or why do you believe it was Mrs. Garcia, Mr. Garcia's new spouse?
The pictures posted on the Mommy and Me page, only she and Mr. Garcia would have them, because it was a recording of one of the interactions we had with each other here outside my house.
Okay. Would Mrs. Garcia record you when she would participate in the exchanges of the children?
Yes.
What did that Mommy and Me Facebook page mention?
It mentioned abuse of Natalie, that I was allowing my boyfriend to abuse her and that I had knowledge of it. And it mentioned our place of employment for both of us and pictures of both of us.
Did it also name you individually and your current partner?
Yes.
First and last names, correct?
Yes.
Do you believe that by posting your photographs and your names and your place of employment, that it could have easily been determined your daughter's identity?
Yes, definitely.
Your daughter does no knowledge of that Facebook post, correct?
Correct.
Do you think that's, or did you address that issue with Mr. Garcia?
No.
But you did report that to the Laredo Police Department, correct?
Correct.
And you had asked the court to assist you in the investigation of that anonymous post.
Yes.
Through my office, Ms. Arce, can you let me know if we, on your behalf, filed an advisory to the court stating that Mr. Garcia's partner deactivated her Facebook page after the court granted that order for the investigation?
Yes.
How are your children doing now, Ms. Arce?
They're doing great.
Were they initially going to counseling?
They were. Yes.
Okay. And they've been successfully discharged from that counseling?
Yes.
If your children should need any additional counseling based on this termination of parental rights, are you going to be seeking out any counseling for their well-being?
Yes.
Have you had any issues with Mr. Garcia still attempting to visit the children?
Yes.
Okay. How many times did he visit the children or attempt to visit the children?
Twice.
Twice since what date?
Since he visited on the first day of school in August, and recently, maybe in the month of October it was. And he sent cupcakes and a gift on November, I think November the 5th, for Natalie's birthday.
Are you asking the court to have him cease all of that activity, visiting, contacting them, sending presents, because that's not going to be in the children's best interest?
Yes.
Have you had any issues with Mr. Garcia trying to access any school information regarding the children?
Yes.
What has he tried to access?
Well, I know he has accessed Skyward, where he gets report cards, and he's in the Class Dojo app.
Did he access those at that Dojo app and that Skyward program since September of this year?
Yes.
And he's never told you that he does not want to proceed with a termination, correct?
Correct.
Have your children received any type of derogatory marks or any bad grades at their school since they're stopped seeing their father in May of 2025?
No, they've actually received Student of the Month and numerous compliments from the teacher by their behavior and their grades.
Okay. Are you asking the court to grant you the termination as being in the children's best interest?
Yes.
And the reasoning are the lack of co-parenting ability between you and Mr. Garcia,
Yes.
and the source being Mr. Garcia's new spouse?
Yes.
Are you asking the court to grant you the termination and also a permanent injunction where he will not be allowed to go near the children's residence, any school they may be enrolled in, or accessing any of their medical or school records?
Yes.
You do understand that if you stay in Laredo, the children may encounter Mr. Garcia, correct?
Correct.
And you're also in agreement that you'll steer the children away to avoid any issues that might hinder the children?
Yes.
I'll pass it witness, Your Honor.
Mr. Jose Garcia, do you have any questions for Ms. Arce?
Yes. Do you have evidence that sustain those accusations regarding the Facebook?
The pictures and the recording?
What pictures? Do you have the evidence? Did the judge grant for LPT to investigate? What was their findings? Who posted them?
Judge, I'm going to object because you did order that, but no order was signed, so I could not submit anything to
It was
the court.
all of this is speculations. The post happened. When was it? Was it in September?
Your Honor, I'm going to object to this because he's already stated he's in agreement to the termination. Why he's so steadfastly defending who posted that anonymous Facebook post
To clarify
What's your clarification?
that it wasn't me.
Well, I don't think there's evidence in the record that it is you. I
What
don't think
what evidence, sir?
there is no evidence. That's what I just said. There's no evidence that it is you. I don't think she's saying it's you. She's saying it's your wife. Right?
Does she have any evidence regarding that?
That's a question to you, Ms. Arce. Go ahead.
Wife, how come we just don't subpoena my wife?
So this is the time that you get to ask questions to Ms. Arce. Ms. Arce, the answer to the last question?
Can you repeat the question?
You're only mentioning my wife. Why don't you subpoena her to the court?
We did request for them to investigate, to subpoena, for LPD to investigate, but the
Oh.
order was not signed.
Any other questions for Ms. Arce, Mr. Garcia?
No, sir.
Ms. Leticia Garcia, any questions for Ms. Arce?
From the guardian ad litem, Your Honor, I don't.
All right. Ms. Catherine Garcia, any questions for Ms. Arce?
Just very briefly, Your Honor.
Sure.
Ms. Arce, what are the ages of Natalie and Nathan?
Natalie just turned 8 years old. Nathan, 6.
And do they have an established relationship with Mr. Jose Garcia, their father?
They had. Yes.
Okay. Do they know him as their father?
Yes.
And do they call him dad?
Yes.
Okay. And you're currently married?
No.
You're not married?
No.
Okay. What are your current sources of financial support for these children?
My boyfriend, we live together, and he is our source of income.
But you're not married?
No.
Okay. Do you work?
No.
So besides your boyfriend, are there any other sources of financial support for these children?
No.
And what sort of health and dental insurance is available for these children right now?
They have Medicaid.
Okay. Okay, that's all the questions I have for Ms. Arce.
All right. Ms. Soto, any other witnesses?
No, Your Honor, but can I ask some questions on redirect to Ms. Arce?
Yes, sorry, go ahead.
Yes, thank you. Ms. Arce, the kids have been on Medicaid since the date of your marriage, correct? Since they were born?
Yes.
Okay. And you are college educated, correct?
Yes.
What is your degree?
I have a bachelor's in psychology.
Okay. Are you planning on any future employment with that degree?
Yes, I'm actually trying to become a teacher.
Okay. So once you complete whatever requirements you need, you are going to seek employment as a teacher, correct?
Correct.
Will you seek to have your children enrolled in health and dental through your employer at that time?
Yes.
And this new boyfriend that you've met, how long have you been with him?
3 years.
And you do have a child with that person, correct?
Correct.
Your relationship with, what is his name, Rob,
Mm,
right?
Robert.
Is
Yes.
his name Robert? Okay. It is a long-standing established relationship.
Yes.
I'll pass the witness, Your Honor.
Mr. Garcia, do you have any other questions for Ms. Arce?
No, I do not, sir.
Ms. Catherine Garcia, any other questions for Ms. Arce?
No, Your Honor.
Any other witnesses, Ms. Soto?
No, Your Honor.
Mr. Garcia, you're under oath. What, if anything, would you like to tell the court?
Can you interview our children?
Well, this is a termination, not a conservatorship issue.
I'm sorry.
What else, if anything, would you like the court to know, or what else do you want to put on the record or say?
Nothing, Your Honor.
All right. Ms. Soto, any questions for Mr. Garcia?
None, Your Honor. Well, so just one. Mr. Garcia, you are willing to proceed today, correct?
Correct.
So your rights are going to be terminated, and the additional requests that were read into the record by Ms. Garcia, you're in agreement to that, correct?
Correct.
All right. Thank you, Your Honor. That's all I have for Mr. Garcia.
Ms. Catherine Garcia, any questions for Mr. Garcia?
Just briefly, Your Honor. Mr. Garcia, do you feel it's in the best interest of your children that your parental rights are terminated?
No, ma'am.
And why do you say that?
No. They should have the privilege of having a father, being there for them for guidance.
You've indicated earlier that you were in agreement are you, is this your voluntary agreement to terminate your rights? Or were you pressured into agreeing to terminate your rights?
And I object to leading.
Mm.
No, I was,
You can rephrase.
Oh, I'm sorry. Mr. Garcia, are you voluntarily agreeing to terminate your rights today?
correct.
Okay, even though you don't believe it's in the best interest of the children, this is your agreement?
Correct.
Okay. Has anyone offered you anything or pressured you to terminate your rights?
No, ma'am.
Okay. That's all the questions I have for Mr. Garcia.
Cross-examination?
Yes, Your Honor. Mr. Garcia, you sent Ms. Arce a text that you wanted to terminate your parental rights, correct?
Correct.
She didn't ask you to do that.
No, she did not.
Okay. And that text that you sent her on app close was May 28th, 2025, correct? Day before your birthday?
Correct.
Okay. And maybe about 2 months before that, you had received a copy of a motion to modify requesting modification of child support that was going to increase your child support and request to investigate the Laredo Police Department for the Facebook post, correct?
No, ma'am. I wasn't.
You never got a copy of it.
No, I did not.
I couldn't hear you, so I'm sorry. What did you say?
No, I did not.
Okay. So you had an attorney at that time, correct?
That's correct.
Who was your attorney?
I believe it was Sierra.
Okay. And you're claiming Ms. Segarra never advised you of the motion to modify child support and of the request to investigate the anonymous Facebook post?
No, it was. She did mention about the child support, and I forward all my W-2s because there was miscalculations, and that's all I have.
Okay. So after you receive that notification of a child support modification, you then send a text to Ms. Arce saying you don't want to be the father, correct?
Not in those terms, but yes.
Okay. Well, you didn't say that you didn't want to be the father until you got the child support notification, correct?
I believe I have the message. Do you want me to read the message?
What message, sir? What are you talking about?
And the app close. The message that I sent to Ms. Arce.
We don't need that. I'm asking you, you already knew you were facing a child support modification when you sent that text in May stating, I don't want to be the father.
Not for the modification. It was because of the fighting. I was tired of the fighting. That was it.
Okay, great. Okay. Do you think it's in the child's well-being to have fighting between parents or step-parents?
No, ma'am.
Do you think the child is going to be happy when step-parents and parents are fighting?
No.
Okay. I'll pass the witness, Ron.
Any questions? Any other questions for Mr. Garcia? Ms. Garcia?
No, Your Honor.
Any other witnesses? Ms. Soto?
No, Your Honor.
Mr. Garcia, do you have any witnesses?
No, Your Honor.
Court, I guess if there are no other witnesses, the court will hear closing from Ms. Soto, Ms. Garcia, and then Ms. Garcia. Ms. Soto, you're closing?
Yes, Your Honor. The parties that were divorced entered into a extended possession order for the children. And I believe the evidence that was established at today's prove-up hearing and at the August 2025 hearing was that there was a lot of conflict between my client and stepmother. A lot of derogatory comments that were shown to the court that my client testified to on that date and today, where Mr. Garcia was not the one communicating or handling any of the communication between the parents about the children. He was leaving that up to the step parent. My client did have a modification of child support. This petition was not made at her request. It was Mr. Garcia's request to have his parental rights terminated. That anonymous Facebook post is attached to our motion to modify. And my client testified why she believes that it was made by step parent, Mrs. Tiffany Garcia. She's also testified that she was alarmed, of course, because it harms her possible employment and her partner's employment. But more importantly, Your Honor, her child could have been very easily identified as a victim of a false allegation of sexual assault. That was not something minor. Mr. Garcia claims he doesn't know that, but I find it very hard to believe that Ms. Cigarroa would not have told him that that's what we were requesting, and that was the evidence that we had presented to the court in that motion. Mr. Garcia has tried to see the children, and my client does not want that to continue. If he's voluntarily terminating his parental rights, the children are doing well. They were in counseling when their relationship with their father and the possession order was intact. They've been discharged. They're excelling in school. Their grades are not being affected. And the counselor doesn't think that she needed to continue counseling. If Mr. Garcia is going to keep interacting with his children, these kids are going to end up back in counseling. He needs to stay away. He needs to understand this is his choice. He's already testified that to the court. It is in the children's best interest to have a peaceable life without any step parent or parent creating any conflict for them. They're in a good state right now, and we want to keep it that way. I know the state had concerns about my client's ability, but the Medicaid happened even when Mr. Garcia was the father. My client is moving forward with trying to get a teaching position and providing for her children. She's not going to be on Medicaid with the children forever. She has completed her degree. She's going to be able to provide for the children and provide them with a stable life environment. So for those reasons, Judge, we are asking the court to terminate Mr. Garcia's parental rights and include any additional language that Mrs. Garcia the ad litem feels necessary for the children's well-being.
Court will hear a closing argument and statement from the Attorney General's office.
Just real briefly, Your Honor, Your Honor, that the evidence before the court shows that these children, ages 8 and 6, clearly have a relationship with their father, Jose Garcia. There is no person in this case able to stand in and adopt these children and assume financial responsibility for them. The children are on state assistance. The mother is unemployed. The only source of support for these children is her current boyfriend. The father clearly wants a relationship with these children. He wants to see the children, and he testified he does not believe it's in their best interest that his rights be terminated. I did not hear any evidence that there was any other. The evidence before the court is that this main source of conflict is Mr. Garcia's current wife, Tiffany, and that the fighting among the parents is causing them not to be able to co-parent. But what I didn't hear were that there were any alternatives proposed for dealing with Mr. Garcia's wife, or any curtailment of possession and access or restriction on terms or anything like that. And it seems to me that there would be some effort to find an alternative to terminating Mr. Garcia's rights, which doesn't just affect, and you don't have to pay child support anymore, but it terminates the children's rights to inherit from Mr. Garcia. It terminates their rights to any Social Security benefits down the line. So from the state's point of view, Your Honor, the parties have not met their burden of proof by clear and convincing evidence to terminate Mr. Garcia's rights.
Thank you, Ms. Garcia. The court will hear a report and recommendation from the ad litem, Ms. Leticia Garcia.
Your Honor, I understand where Ms. Catherine Garcia is coming from when she speaks of alternative means or methods of visiting. I went there with Mr. Garcia. We spoke about this. And in this particular case, it's not feasible. He's got a little baby, a new baby with his current wife. The relationship that he has with his current wife is such that it's a hindrance for him to attempt to maybe see the kids on the outside by himself. That would not be possible. We spoke about that, and that's just the nature of their particular relationship. And I understand he's emotional, and I get where he's coming from, and that is exactly why I suggested other things to him as well. But being very practical in terms of day-to-day living, it was not going to be possible. He could not sneak around behind his current wife's back and the new baby and try to do things on his own. That just wasn't going to happen. So he decided willingly, voluntarily. We spoke at length various times, it on the phone, in person, and I understand where he's coming from. And even though I would not normally agree to leaving these children without their father or a role model, I do understand that they have a good relationship with Robert. They've lived with him for 3 years in the same household. He's a good provider. They've got rules in the house. The kids are getting good grades. And I feel that is the only way that we can go, that is definitely in the best interest of the children. And Mr. Garcia himself admitted that to me various times. And for all of these reasons, plus the statements I made earlier before we had testimony taken, I do recommend that this termination be granted. And I'm wondering whether Ms. Garcia from the state needs to have Ms. Arce ordered to pay for the Medicaid, at least now, so that the state can receive some funds for that insurance.
All right. Thank you, Ms. Leticia Garcia. Would any other person like to be heard? In other words, is there anything else that needs to be put on the record before the court makes a decision?
Your Honor, just that we do have a current case. There are arrears on the current child support should the court grant determination of rights. So we are going to be requesting judgments on those arrears. I have not filed an updated FINA of what the amounts are, but I will do so.
All right. Well, Mr. Garcia, Ms. Arce, you certainly don't give and present an easy case for the court, at least easy emotionally. But I think the facts and the evidence are pretty clear in this case, and this is what makes my job unpleasant in these situations, but clear and not easy per se, but just the decision just based applying the law to the facts in your case. So a couple of things. I was concerned with the thoughts, statements, and comments by Ms. Catherine Garcia as to what alternatives, if any, had been considered. The response came from Ms. Leticia Garcia and her involvement, discussions and assertions of the facts as they exist in the situation, and the court takes judicial notice of the entire case file, including the last hearing, where the universe of evidence in this case, there is no other possible source for these posts. At least in this case, with the evidence presented, there's only one person that has any motive, desire, or motivation to post these things. I mean, if there is another person that has different set of motives, that just has not been presented to the court. The striking thing for the court here is that there is a request, a mutual request to terminate rights on both sides. Although Mr. Garcia says that it isn't in the best interest of his children, it's a request that he initially made. In other words, he's the person that planted the seed, that got the ball rolling, and that because of that, Ms. Arce went out and hired a lawyer, and now we're all here based on an idea that he had, that he agrees to, even though he says, well, it's not in their best interest. But I think that the truth lies in what Ms. Leticia Garcia has uncovered, is that his new relationship takes precedent. Now, I'm going to make some notations on the record, Mr. Garcia, and I need you to understand that I don't judge you as a person. You know, everybody's here as an adult and everybody makes their decisions, and I don't judge you for your decisions, but I do have to judge the facts in your case, not you as a person, but the facts in your case as they exist, and then I'll apply the law to give you a result. But it's clear to the court, based on the last hearing and based on the evidence and testimony and the report and recommendation of Ms. Garcia, is that in your situation, you have chosen the best interest of your marital relationship over the best interest of your children per se. That's the facts. I can't change that. You've made that decision, and I'll make mine based on those set of facts. I do understand and appreciate the argument of the state that these children should be well taken care of financially. The consideration the court has, though, is that what situation is not going to place them in any harm or danger? In other words, what situation is going to avoid them getting exposed in public to potential false allegations of anything terrible? That's definitely not in their best interest. So, and I think the best interest of the children to be safe and free of danger, or even any misinformation in the public, is greater than financial interests. And the court has heard testimony that their financial well-being is well taken care of. Right. Given all of this, in cause number 2022 FLA 1334C3, the court finds that there is sufficient information, evidence, and testimony in the record to permit the court to make a finding that there is clear and convincing evidence, one, that it is in the best interest of the children to grant the termination and approve the parties' agreement. The court finds that this is in the children's best interest to avoid any further misinformation, harm, or any misinformation in the public. These are the orders of the court. The orders are due on or before
December the 15th at noon by submission.
Anything else on this case, Ms. Soto?
No, Your Honor.
Ms. Catherine Garcia?
Your Honor, on the underlying case, the SAPSR, as of today, we are showing that there's child support arrears still owing in the amount of $2,155.47. We're also showing there's medical support arrears of $200.25. We would request judgments on both of those amounts with a repayment amounts. I will get with Ms. Soto and send her a copy of the FINA with a proposed order in the SAPSR case, and we would ask that the court grant those judgments.
Any objection to that request, Ms. Soto?
No, Your Honor.
Any objection to that request, Mr. Garcia?
No, Your Honor.
Any objection, Ms. Leticia Garcia?
No, Judge, but Catherine, we can incorporate all of this into this one order, and would that be easier for you?
So I believe the SAPSER has one cause number and the
Okay.
termination suit has a separate cause number.
Got it.
And that, okay. And so I think both cases are on the court's docket today and we'll submit the order confirming arrears under the SAPSER cause.
I think that's right. All right. Mr. Garcia, yes.
A good question. Those arrears do I have to pay those or who's going to pay those? Or how would that work?
So, Your Honor, we're requesting judgments granted on the arrears amount. Going forward from today, current child support will stop, but the arrears will be paid back. And while we're addressing this issue, the current support I have, the current support was $638 and medical was $50. So on the arrears, we would just ask those amounts to remain until the arrears are paid off.
I'm sorry, that what amounts remain?
The current child support now, before termination of rights, was $638 a month. That was current support. Medical was $50 a month. So now that there won't be any current support owed, we're just asking the repayment amounts just stay the same. $638 on the child support arrears and $50 a month on the medical support arrears.
But not as, but the current amounts, not as current amounts, but as as arrears amounts.
Correct. Just repayment on the arrears.
Got it. Did you understand that, Mr. Garcia?
I did not, sir.
Okay.
So basically, before, what the Office of the Attorney General's office is saying is that you owe $2,100. They're asking for a judgment on that, but your obligation for child support stops today, but your repayment amount on the arrears continues the same. So you still have the same financial responsibility until the repayment of those.
But we had an order signed, I believe it was on May Soto, correct? To stop.
So, Judge, as part of his request that his parental rights be terminated, Ms. Segarra communicated that he also wanted his child support to end in May of 2025. Mr. Garcia had that request as well. When we came to that first hearing, Ms. Garcia disagreed because she had not been, I guess, copied or conferred or served with anything. So she objected to that order of termination of child support until the court could hear the termination case. I think that's procedurally what happened regarding that order.
Well, it sounds like there is an arrear amount. The request is to take a judgment. It sounds like Mr. Garcia had a request to terminate that situation back in May.
Okay.
Ms. Soto, what is Ms. Arce's position with regard to the judgment and any possible relinquishment, if any?
Your Honor, if the arrears from June 2025 forward, Ms. Arce does not have an issue waiving those arrears.
I'm sorry, I didn't understand.
So Ms. Soto is informing the court that Ms. Arce would relinquish any arrears from June to the present.
Oh, okay.
Based on that voluntary relinquishment of arrears, Ms. Garcia, does that, how does that affect the arrears, if at all?
So, Your Honor, I think what's happened, the court did sign an order terminating child support and withholding. And I don't know the exact date of that. I don't think we've entered that order as far as stopping the accrual of the support. So let me make sure that we have that order entered properly, that the accrual stopped, so that I will have the correct arrears amounts. And then that would be a different balance on the arrears if it's of a different date. So
well taken, the court will reaffirm that
okay,
that stoppage date, and the court will now make a finding that there's an agreement in any event that the amount by Ms. Arce due to the child is relinquished from June going forward. And I'll give the party some time to calculate what the amount is, if there is any, and the court will take a judgment on whatever amounts are owed after that, if there are any, and there may not be. All right. Anything else from any person here? Ms. Arce, Ms. Garcia, Mr. Garcia, Ms. Soto, anything else?
Your Honor.
All right.
Your Honor, the only thing is that once we prepare this order, we can send it to Mr. Jose Garcia and have him review and sign off on it by DocuSign, just so that the court knows that he's had a chance to approve the amounts and the repayment terms.
I think that's a good idea. Ms. Flores, is Mr. Garcia on the e-serve list? Actually, even if he's not, just send it to him directly so that he can sign, and then you can upload and e-file the agreed to sign, or at least agreed to inform order. All right. Anything else from any person?
No, just wanted to thank Ms. Garcia and Ms. Leti Garcia. This was a very difficult case, as the court could see, involving very serious issues regarding the children, and she did a fantastic job as always. So we really appreciate the time she dedicated to the children on this case.
The court appreciates all the time and effort that was spent by every person on this case. I wish everyone the best, especially these children. Good luck to all.
Thank you, Judge.